Supreme Court has ruled on the Trump immunity case, essentially dealing out what looks to be, and what all reports are saying, it's a hefty opinion, but what is being considered a big win for President Trump.
That's right. The court held that under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. And he is entitled to at least presumptive immunity from prosecution for all his official acts. And then they go on to say that there is no immunity for unofficial acts. And then they go on as well to say the judgment of the Court of Appeals for the 11th Circuit, or for the D.C. Circuit rather, is vacated, and the case is remanded for further proceedings consistent with this opinion. So the guidance that comes out of this opinion will feed into the case at the D.C. Circuit Court of Appeals with Judge Chutkan, or the D.C. Circuit Court rather, and we will go now and see what happens as they have to start back there and parse out what would be an official act and what would be an unofficial act. But it really guts a lot of the case for Jack Smith, including this section here, because one of the cases is conspiracy to defraud the United States, a very broad statute. But it says on page 40 of the opinion, for instance, section 371, which has been charged in this case, is a broadly worded criminal statute that can cover, quote, any conspiracy for the purpose of impairing, obstructing, or defeating the lawful function of any department of government. Virtually every president is criticized for insufficiently enforcing some aspect of federal law, such as drug, gun, immigration, or environmental laws. An enterprising prosecutor in a new administration may assert that a previous president violated that broad statute. Without immunity, such types of prosecutions of ex-presidents could become quickly routine. The enfeebling of the presidency and our government that would result from such a cycle of factional strife is exactly what the framers intended to avoid. Ignoring those risks, the dissents are instead content to leave the preservation of our system of separated powers up to the good faith of prosecutors.
My dad, Jay Secula, is joining us right now. I just want to get your initial thoughts. People want your feedback of what this means and what it looks like for the future for some of these President Trump's cases.
Well, number one, it's a huge win for the president, former president, because the court not only recognized immunity, but they said there's presumptive immunity. In other words, it's presumed that the acts of the president are engaged in are official acts. And then they went through a litany of the indicted facts and said that most of those were official acts. There's only a couple that John Roberts is sending back to the trial judge for an evidentiary hearing. And even on those, it's presumed, he says that in the order, in the opinion, it's presumed that those are official acts. By the way, the opinion tracks very closely to the brief that we filed, and it also cites frequently to the cases we argued for President Trump 4 years ago at the Supreme Court, Trump versus Vance and Trump versus Mazar. And both of those cases are cited extensively justifying the presidential immunity here. Let me tell you something that a lot of commentators are not picking up. This will end the case in Georgia against President Trump, because remember, that conversation that serves as the basis of that lawsuit, it was strictly the phone call to Brad Raffensperger. Well, under the court's analysis, that is not only presumed official act, that is an official act. So I think Fani Willis's prosecution of the president is dead.
How does it affect the cases moving forward, or the ruling that's coming, or even the sentencing that's coming? Does this play a factor?
Yeah, so like as I said, I think the Georgia case is totally dead, I think, as it relates to President Trump. So I think that's over with. Rashan's was a state criminal proceeding on business records. Probably doesn't apply to that at all. I think the same's true with the New York AG case. Not likely to apply here. And then it'll raise issues that I'm sure will be litigated. But I think the Georgia case, which was the next pressing case for the president, is got serious trouble. And I think Judge Cannon's case, the document case, it's also got serious trouble, because he's going to argue, the president will argue, that those records were taken in the context of official acts of the presidency. Remember, they were moved down before he was still in office.
Well, I think it's important to note that this particular opinion does not necessarily establish presidential immunity. that is established by the Constitution pursuant to the separation of powers. So it's embedded within our constitutional structure that the president needs immunity in order to function properly. Otherwise, he or she would be hamstrung with respect to engaging in conduct that might indeed be seen questionable after the fact. That's number one. Number two, the happiest two individuals with respect to this opinion are Barack Obama and Joe Biden, because essentially their conduct, particularly official conduct, is now subject to immunity, and the Supreme Court has made that very, very clear. Thirdly, I would argue that Justice Roberts was very intent on establishing this principle for all future presidents, not simply President Trump. So I think this is a win for the Constitution, it's a win for the American people, and it's a win for democracy.
I think most people are sitting, listening to the Supreme Court decision and saying it's common sense, right? Donald Trump has immunity for everything he did as president because that is common sense. Of course he should, because he's got to make the best decisions. Sometimes those are tough decisions. But the personal aspect is where I think the left is going to try to wiggle their way in. But as president, there's not much that you're making that is personal. Everything you're doing is about the job because you are president of the United States. This seems like common sense to me, but seeing the left completely melt down with really crazy radical theories, I think that what so many people on the left did is they just read the minority opinion and they didn't read the majority opinion, and now they're screaming about the slippery slope of the minority opinion. But I think what people have to recognize is that the minority opinion, they lost. There were 3 of them, and 6 judges said, no, you're wrong. And so the majority opinion is what rules the day. And I think people just need to calm down, read it. It's full of common sense. It makes sense to the average person.
All of the cases brought by Jack Smith should fall apart, and you would then need to appoint a different individual who would, I think, have to go before a grand jury and to bring these cases in the future. So this means at the end of the day, I think, at least from Justice Thomas' perspective, that all of these cases fall away. And as Jay pointed out correctly, I think, the Georgia case goes away, the Jack Smith case in Florida goes away, and the election interference case goes away. And so I think at the end of the day, what have we seen? We have seen a waste of millions upon millions of dollars in the prosecution of a former president, and there is no legal or constitutional basis for these prosecutions.
Do you think they go away regardless if President Trump wins re-election?
I think that is correct. I think that is correct.
A lot of people are obviously saying if he wins, a lot of these are dead. But so whether he wins or loses, these cases should go away. And it provides basically an object lesson for any future president. If you are going to appoint a special counsel, make sure that special counsel was duly appointed. Otherwise, it is a waste of time. And typically, as we have seen with Jack Smith, virtually everything he does is a waste of time.